Good afternoon and welcome to True Great Crime. I'm your host, Mama Libra Scales. Today I'm going to be covering the reading of the newly filed motion to dismiss that has been filed in the state of Indiana versus Richard Allen cause. So I'm going to go ahead and share my screen and get started. So, we have the State of Indiana versus Richard Allen memorandum of law in support of defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. At issue is the purposeful or negligent failure to preserve and or the destruction of material and exculpatory evidence critical to the defense of Mr. Allen. It also involves the attempted concealment of the identity of a key witness, later identified as Professor Jeffrey Turco, and other exculpatory evidence, such as the Todd Click letter and evidence referred to by Click in his letter. This would include new examples of missing evidence detailed in the motion filed simultaneously here within. Indiana Code 35341-4 states that this court may, upon motion of the defendant, dismiss an information upon certain grounds. In this case, the defendant requests the court to dismiss this information pursuant to Indiana Code 35341-4, which states that a motion to dismiss an information may be granted for any other ground that is a basis for dismissal as a matter of law. 35-34-1-4A11, such grounds would include a violation of a defendant's constitutional right to due process. Additionally, trial courts have inherent authority to dismiss criminal charges where the prosecution of such charges would violate a defendant's constitutional rights. Section 35-34-1-4 is merely legislative recognition of this authority. Matlock v. State, 944 NE 2D 936 938, Indiana Court of Appeals, 2011. See also State v. Davis, 898 NE 2D 281 285, Indiana, 2008. Such grounds would include a violation of a defendant's constitutional right to due process. A motion to dismiss based upon a ground specified in Indiana Code 35-34-1-4A11 may be made or renewed at any time before or during trial. See Indiana Code 34-34-1-B, 1-4B. Therefore, in this matter is properly and timely raised. The Indiana Supreme Court has held that a serious breach of duty occurs when the prosecution willfully or intentionally, when unjustified by a public policy, obstructs the access of a defense to material evidence in its possession. Turnpaugh v. State, 521 NE 2D 690, 692 through 93, Indiana, 1988. It is likewise a serious breach when, through lack of vigilance, the negligent destruction or withholding of material evidence by law enforcement officers or the prosecutor occurs. In such instances, grounds for reversal may exist. The Indiana Supreme Court has also held that the negligent or intentional destruction of evidence by the police can provide grounds for reversal or dismissal on due process and due course of law grounds. C. Berkla versus State 323 NE 2D 645, Indiana 1975. Hale versus State 230 NE 2D 432, Indiana 1967. Rowan versus State 431 NE 2D 805, Indiana 1982. And Braswell versus State 550 NE 2D 1280 1283, Indiana 1990. Hi, Adrian. Yes, it's so excited to hear your take. Thank you. Emmy Sue, listening while driving. Hi, Emmy Sue. Welcome in, guys. If I don't see your comments like right away, it's because like I'm not looking at the main screen. Like I have you guys on the big screen for comments, so I just kind of see it out of the corner of my eye. I'll keep going. Prior to any request for discovery by the defendant, the negligent destruction or withholding of material evidence by the police or the prosecution may present grounds for reversal. Berkla 323 NE2D at 648, citing Hale versus State 230 NE 2D 432, Indiana 1967. The Indiana Supreme Court has further held that when the prosecution determines evidence to be non-material and further decides not to advise defense counsel of such evidence prior to its destruction, a heavy burden rests upon the prosecution to demonstrate that the destruction of such evidence did not prejudice the defendant. ID at 649. The appropriate test to apply when deciding whether a defendant's due process rights have been violated by the state's failure to preserve evidence depends on whether the evidence in question was potentially useful evidence or material exculpatory evidence. Blanchard versus State 802 NE 2D 1426, Indiana Court of Appeals 2004. The burden is on the state to demonstrate that this evidence was not material and its destruction did not prejudice the defendant. Cox versus State 422 NE 2D 357, Indiana 1981. Potentially useful evidence is defined as evidentiary material of which no more can be said than that it could have been subjected to tests, the results of which might have exonerated the defendant. The state's failure to preserve potentially useful evidence constitutes a due process violation when the defendant can show bad faith. The Seventh Circuit has held that bad faith may be inferred when a party disposes of evidence in violation of its own policies. C.E.G. Park versus City of Chicago, 297 F3D 606 615, 7th Circuit, 2002. Citing Lattimore versus Citibank Federal Savings Bank, 151 F3D 712 716, 7th Circuit, 1998. Violation of a record retention regulation creates a presumption that the missing records contained evidence adverse to the violator. The bad faith presumption arises when the failure to retain records or other evidence actually violates the terms of the applicable policy. However, the Indiana Court of Appeals has noted that in some instances, the destruction or failure to preserve evidence may be so prejudicial to the defendant as to warrant reversal, even in the absence of bad faith by the officers. Stoker versus State, 692 NE 2D 1386 1390 N8, Indiana Court of Appeals, 1998. Material exculpatory evidence, on the other hand, is defined as evidence that possesses an exculpatory value that was apparent before the evidence was destroyed, and is of such a nature that the defendant would be unable to obtain comparable evidence by other reasonably available means. Blanchard, 802 NE2D at 28. The state's good or bad faith in failing to preserve material exculpatory evidence is irrelevant. The Indiana Supreme Court has held that the defendant must establish materiality as a condition precedent to claiming a denial of due process where evidence is negligently lost or withheld by the government, except where the materiality is self-evident or a showing of materiality is prevented by the destruction of evidence. Lee versus State, 545 NE 2D 1085 1089, Indiana, 1989. An item is material if it appears that it might benefit the preparation of the defense's case, or if it might reasonably affect the outcome of the trial. See Williams versus State, 819 NE 2D 381 385, Indiana Court of Appeals, 2004. In this matter, given the nature of the evidence, the law enforcement either failed to preserve or actually destroyed the materiality was and is self-evident. Furthermore, as in Lee ID, the failure to preserve or destruction prevents the defense team or the defense from establishing the exculpatory nature of the evidence and its materiality. As such, Allen is not required to demonstrate the materiality of the evidence. See Lee 545 NE 2D at 1089. To be sure, the unavailable evidence had exculpatory value, which was apparent at the time it should have been preserved and prior to its destruction. Additionally, Allen is unable to obtain comparable evidence by other reasonably available means. See Blanchard, 802 NE 2D at 28, and see E.G. Glotzbach, Glotzbach and Froman, 854 NE 2D 337 338, Indiana, 2006. Spoliation of evidence is the intentional destruction. Hold on one second, y'all. Sorry. Let's see. Spoliation of evidence is the intentional destruction, mutilation, alteration, or concealment of evidence. If spoliation by a party to a lawsuit is proved, rules of evidence permit the jury to infer that the missing evidence was unfavorable to that party. Hey, Kayla, welcome in. Welcome in. Even if this court requires a showing of bad faith, it is apparent. But bad faith is defined as being not simply bad judgment or negligence, but rather implies the conscious doing of wrong because of dishonest purpose or moral obliquity. Not sure if I'm saying that word right. Blanchard, 802 NE 2D 14 at 23 or at 27 through 28. Obliquity is defined as deviation from moral rectitude or sound thinking. See Webster's New International Dictionary, 1682 D.Ed. 1947. The United States Supreme Court has recognized that the police have a constitutional duty to preserve such evidence. In Trombetta, the Supreme Court observed that whatever duty the Constitution imposes on the state to preserve evidence, that duty must be limited to evidence that might be expected to play a significant role in the suspect's defense. California versus Trombetta, 467 U.S. 479 488, 1984, the court recognized the same duty in Arizona versus Youngblood, 488 U.S. 51 1988, confirming that the Constitution, imposes at least a limited obligation on the police to preserve evidence that could form the basis for exonerating the defendant. It is beyond debatable that the evidence at issue here would play a significant role in Mr. Allen's defense and would form a basis for exonerating him. Additionally, the suppression by the prosecution of evidence favorable to an accused upon request violates due process where the evidence is material either to guilt or to punishment. Irrespective of the good faith of the prosecution, Brady versus Maryland, 373 U.S. 887 1963, emphasis added. To prevail on a Brady claim, a defendant must establish, 1, that the prosecution suppressed evidence, 2, that the evidence was favorable to the defense, and 3, that the evidence was material to an issue at trial. Minnick versus State, 698 NE 2D 745, 755, Indiana 1998, citing Brady 373 U.S. at 87. Indiana Constitution. It is clear that the federal Constitution is not the sole guarantor of the right to due process and other rights. Chief Justice Shepard made this abundantly clear in his law review article, Second Wind for the Indiana Bill of Rights, 22 Indiana L. Rev. 575, 1989, when he stated in conclusion that civil liberties protected only by a U.S. Supreme Court are only as secure as the Warren Court or the Rehnquist Court wishes to make them. A protection of Americans against tyranny requires that state Supreme Courts and state constitution be strong centers of authority on the rights of the people. I am determined that the Indiana Constitution and the Indiana Supreme Court be strong protesters of those rights. ID at 586. The Chief Justice also stated that Indiana was an early and noteworthy participant in using its Bill of Rights to defend personal liberty, and after citing to numerous early decisions, noted that these were but a few line of cases in which the Indiana Supreme Court held that the Indiana Bill of Rights afforded Hoosiers rights which the federal Constitution did not. ID at 576 through 77. Chief Justice Shepard also made a note of the fact that many provisions of the Indiana Bill of Rights have no counterpart in the U.S. Constitution, and observed that Article 1, Section 12 was one of those provisions. Indiana at 580 to 581, this provision relating to due process is an issue in the instant case. The Due Process Clause of the United States Constitution is found in Section 1 of the 14th Amendment of the Constitution. That section states, in relevant part, that no state shall make or enforce any law which shall abridge the privilege or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, emphasis added. The right to due process conferred under the Constitution of the State of Indiana is found in Article 1, Section 12, and contains significant language not found in the Constitution of the United States. The provision states, all courts shall be open, and every person for injury done to him in his person, property, or reputation shall have remedy by due course of law. Justice shall be administered freely and without purchase, completely and without denial, speedily and without delay, emphasis added. While the defense is unaware of any Indiana case law specifically interpreting the emphasized portion of this constitutional provision, the provision itself was traced back to the Magna Charta and State ex rel. Board of County Commissioners versus Larimore, 175 Indiana 478 94 NE 761 1911. The Larimore Court acknowledged that although the provision was derived from the Magna Charta, it may be a broader guarantee of free, unpurchased, and impartial justice. ID at Indiana 485 94 NE at 763. Three more contemporary decisions dealing with the issue of destruction of evidence are of particular import. First, it is clear from the Chief Justice Shepard's concurrence in House v. State 535 NE 2D 103 111 Indiana 1989 that the issue of whether a lack of good faith on the part of the state was required for a defendant to obtain a remedy for the destruction of potentially exculpatory evidence under the Indiana Constitution had not been decided adversely to those defendant even after Youngblood. The House decision actually dealt with the discovery of potentially exculpatory evidence and the need for materiality of the evidence. Both Chief Justice Shepard and Justice DeBruler, however, discussed the related issue of destruction or loss of such evidence. In his concurrence and dissent, Justice DeBruler stated that while I agree with the result reached by the majority opinion on this discovery issue, I point out that when the accused shows that material evidence was in the hands of the prosecution and lost, the question of whether the accused must then go ahead and show prejudice is open in Indiana. In my judgment, when the item is not available for scrutiny by the trial court, but is known to have been material, the risk of loss should be borne by the prosecution, not the defendant. The police and prosecutors are, after all, highly trained specialists in the gathering and retention of evidence and should be expected to carefully retain all material evidence in usable form. ID at 111. Chief Justice Shepard, in his concurrence, stated that I agree with Justice DeBruler that this case does not decide what standard Indiana should use for cases in which the prosecution has deposed of arguably material evidence which might exculpate a defendant. The instant case certainly appears to be the type envisioned by the comments. Two Indiana decisions have been found in which the issue of due process and the destruction of evidence was raised under both the federal and Indiana Constitution. Hale versus State 230 NE 2D 432 Indiana 1967, Douglas versus State 464 NE 2D 318 Indiana 1984. Although both of these decisions were determined adversely to the defendants based on the facts of the case. Both also stated that negligent or intentional destruction of material evidence by the police or the prosecution may present grounds for reversal. Hale 230 NE 2D at 435, Douglas 464 NE 2D at 320. In each case, the defense alleged a violation of due process under both federal and state constitutions. While both decisions were rendered prior to the United States Supreme Court's decision in Youngblood Supra, the decision in House rendered after the Youngblood decision makes it clear that the principle announced in Hale and Douglas may still be valid under Indiana Constitution. Additionally, Lee Spira was decided after Youngblood. If the language of Article 1, Section 12 of the Indiana Constitution, justice shall be administered freely and without purchase, completely and without denial, speedily and without delay, is to have any meaning at all, it certainly seems to support a more stringent enforcement of due process rights than required under the federal Constitution. Given the facts of the instant case, the penalty involved, and the long history of concerns about preservation of evidence in Indiana case law, as well as evidence of attempt and law enforcement and state of Indiana attempting to conceal other materials and exculpatory evidence, Mr. Allen should not be deprived of a remedy for the egregious loss of evidence occasioned by the actions of law enforcement and or prosecution in this case, especially in light of the ease with which the evidence could have been preserved. Conclusion: the only remedy that serves the interests of justice and guarantees Mr. Allen's constitutional rights is dismissal. Respectfully submitted, Andrew J. Baldwin, Bradley A. Rossi. And there's the first one. Goodness, that was a mouthful, and the next one's only bigger, like crazy. So I hope y'all are doing well. I'm going to pull up this other one here so we can get it popping off. Alrighty then, and I'm going to share the screen. All right, so here we are. State of Indiana versus Richard Allen. Defendant's second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory or potentially useful evidence. Oh boy. All right. Comes now the accused, Richard Allen, by and through counsel Andrew Baldwin, and pursuant to the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 12 of the Indiana Constitution and Indiana Code 35-34-1-4A11, moves this court to dismiss charges against the accused for destroying or losing exculpatory evidence or potentially useful evidence in violation of the standards set out in Brady versus Maryland 373 U.S. 83, 1963. In support of said motion, the accused states the following. Number one, that on February 7th, 2024, the accused filed his motion to dismiss for destroying exculpatory evidence and memorandum in support of said motion. Number two, in his first motion, the defense detailed how a February 17th, 2017 interview of third-party suspect Brad Holder was destroyed while in the evidence of law enforcement, along with multiple days of other interviews. Number three, on March 18th, 2024, a hearing was held on said matter. It sure was. Number 4, at the March 18th, 2024 hearing, Steve Mullins, investigator for the prosecutor's office, testified that other evidence was destroyed in 2017, as well as it was purportedly unintentionally taped over. Number 5, furthermore, at said March 18th, 2024 hearing, the defense tendered Mullins undated reports that purportedly explained how the evidence was destroyed. Number 6, the prosecution did not tender these reports to the defense until after the motion to dismiss was filed. Also, said reports were only turned over to the defense after the defense requested those items from the prosecution. Number 7, on April 2nd, 2024, this court issued its ruling denying the defense motion to dismiss the charges. Number 8, since the time of this court's denial of said motion, the defense has learned of other exculpatory evidence and or potentially useful evidence that the prosecution has not turned over to the defense and is missing, or that the state of Indiana has destroyed. Number 9, just like Allen's first motion to dismiss, the missing destroyed evidence relates to a third-party suspect, Brad Holder. Brad Holder's missing phone extraction data. Number 10, during a recent deposition of Brad Holder, the defense learned that Brad Holder is pretty sure that he turned his phone over to law enforcement on February 17th, 2017. Number 11, the prosecution has not turned over any data, extractions, reports, or evidence from Brad Holder's phone. Number 12, curiously, on the same day and at the same time that Brad Holder believes that he turned his phone over to law enforcement officers, his son, Logan Holder, also turned his phone, Logan Holder, over his phone. He turned his phone over. 13, the prosecution has turned over the data extracted from Logan Holder's phone, but not any data extracted from Brad Holder's phone. While the data from Logan Holder's phone was extracted, law enforcement apparently claim they have... Okay, sorry. While the data from Logan Holder's phone was extracted, law enforcement apparently claim that they, law enforcement, failed to extract data from Brad Holder's phone, even though both he, Brad, and his son, Logan, turned over their phones to law enforcement at the same exact time. Okay. Jerry Holman stated under oath at a recent deposition that he believes police just looked through Brad Holder's phone, but encouraged the defense to find out for sure from the FBI. Holman, May 3rd, 2024, deposition, page 6, lines 13 through 15. My goodness. Number 16, when asked if Holman would have extracted data from Brad Holder's phone if given the opportunity, Holman was non-committal. Depends on the circumstances. But I think you'd have to ask the FBI what they did. Wow. That's your job, Holman. That's literally your job. You were supposed to be knowing what happens with all of that evidence. Weren't you supposed to be in line, like, as somebody who was, like, hit to the Delphi Homicide Task Force, and you're this guy. You guys are the guys. You know everything. How do you not know what the FBI did and did not do with evidence? I mean, I don't know. Sorry, Jerry, but I think your nose is growing. Just saying. Finally, after being pushed by the defense, Holman finally conceded that he would have extracted data from Holder's phone if given the opportunity. This also came from Holman's deposition on May 3rd, 2024, page 7, lines 8 through 12. The defense finds it highly, highly unlikely that law enforcement would take the time to collect both Brad Holder's phone and Logan Holder's phone, but then choose to only conduct an extraction of Logan Holder's phone, especially when Brad Holder was a suspect at the time. And no evidence provided to the defense suggests law enforcement considered Logan Holder a suspect. On February 17, 2017, documents specifically sought by the defense, Doug Carter's email with the FBI, provided evidence of that. Brad Holder was a suspect within days of the murder, and certainly on February 17, 2017, when Brad Holder was interviewed at the Delphi police station and turned over his phone to law enforcement. B. State Police Superintendent Doug Carter was aware that Brad Holder was a suspect. C. Even the top FBI agents in Indianapolis, Jay Abbott, was aware that Brad Holder was a suspect on February 17, 2017. D. Logan Holder was not mentioned as a suspect in those emails. Number 20. This begs the question, why would law enforcement take both Brad Holder's phone and Logan Holder's phone, but only extract data from Logan Holder's phone when he was not a suspect, but would not extract any data from Brad Holder's phone when he was the suspect? That's a good question. Good question. Additionally, the defense possesses 101 phone extractions that law enforcement conducted on a variety of other phones, many of which seemingly have little or nothing to do with the murders. Number 22. This begs another question. Why would law enforcement take the time to extract data from 101 phones, most of which were not owned by suspects, yet would not extract data from Brad Holder's phone when they had his phone in their hands on February 17, 2017, and he was a suspect at that time? Really? My goodness. The defense believes that the above information provides strong circumstantial evidence that law enforcement did extract data from Brad Holder's phone on February 17, 2017, and has not turned it over to the defense. 24. Logic and common sense support this belief. 25. If law enforcement failed to extract suspect Brad Holder's phone data while it was in their hands on February 17, 2017, then the only other explanation would be that law enforcement was completely and utterly inept. Interesting. Right? It is so obvious. But see, that's probably why you got Tobe in those interviews. You know, remember when he did that interview with the Down the Hill podcast, you know, and he was saying how they were inexperienced in this, and, you know, they didn't know what they were doing. They admitted that they didn't know what they were doing. But I think a long time ago, they were trying to get out in front of this, you know, like, just like the whole bullet on the desk thing, like on full display, that will never like be gone from my mind. But what gets me more is Tobe was on the news at one point talking about I was a suspect. Hey, even I was a suspect at one point. And it was the strangest thing I've ever seen in my life. I don't think I've ever seen a law enforcement officer look so gleeful when he was talking about how he was at one point a suspect. Like, I don't understand where your brain just I don't know. Maybe the hamster ran out of energy that day. It had to stop, take a minute. That, or, I'd say something else, but I don't. I don't want to get myself in trouble. But it could be a suggestion. Perhaps put the pipe down and let the drugs go. That'd be a good one for you. Anyway, so let's see. All evidence of Brad Holder's second interview with law enforcement is missing. 26. Additionally, Brad Holder testified in his deposition that in addition to law enforcement, February 17, 2017 interview, which was purportedly accidentally taped over, that law enforcement conducted a second interview of Brad Holder sometime later, probably within a year or two of his first interview. Okay, hold up. Wait a minute. Let's put some logic in it. Okay. I've said this before because I listened to that stuff that happened on the March 18th hearing. And I listened to how this whole 6 terabyte hard drive, either it got unplugged, a switch got left on, or somebody just basically didn't get up and physically go press a stop start button. So again, this is 6 terabytes of hard drive, and it was fairly new. Steve Mullins testified that this sucker was fairly for real new. He installed it himself. He was a handyman who installed it. Let me ask you something, Mr. Mullins, respectfully, even if you have 4 interview rooms within your police department. My question is 6 terabytes of hard drive would carry over 1.5 million minutes worth of video and audio. How in the world from February to August in 2017 did you have that taped over something that was new, fairly new, and you realize it in August? You realize this whole situation. You're not keeping a proper log of all of these different witnesses that you've had coming in and out. You said this yourself, Mr. Mullins. You did. Y'all, even after you realized that the interviews and stuff were gone, not a single one of your officers in your department made an effort to go back out, to retrace the steps, to re-interview possible witnesses. All of that is important information. And with the town, your population is what, maybe 3,000, maybe double a high school graduation. And you're telling me that you got so much crime that you're going to run through 6 terabytes of a hard drive, and you got recorded over. I mean, what are you going to tell me next? That you laid a magnet on top of the machine and walked away from it? All right. Rant done there. I digress. Anyway, number 27, Holder further testified at his deposition that A, law enforcement conducted this second interview at the Logansport police station. B, the interview took about an hour and a half. C, the interview was likely videotaped in an interview room. And D, the interview involved much questioning about Patrick Westfall. After the deposition, the defense alerted the prosecutor's office that the defense had A, no phone dump extraction evidence from Brad Holder's phone. And B, no evidence whatsoever in the form of video, audio, reports, notes, or any other type of evidence of law enforcement's second interview of Brad Holder at the Logansport Police Department. What? How shocking. You mean to tell me that there's a second police department that is like, where's that interview? Where did that go? Allie Tara, hi, welcome. It's good to see you. Welcome, welcome, welcome. Give me just a second. I've got to grab the charger for my laptop. I didn't realize that I was this slow. So if you guys give me just one moment and talk among yourselves for just a second, I'd appreciate it. Okie dokie, Pachoki, I'm back. Sorry about that, y'all. But yeah, so here we go. We got Brad Holder's second interview with the Logansport police station. There's no evidence in the form of video, audio, reports, notes, nothing of any evidence that law enforcement even had a second interview with Logansport police station, which is really strange to me, you know. On May 13th, 2024, the prosecution advised the defense by email that they cannot locate an interview of Brad Holder at the Logansport Police Department and have no record of Brad Holder's phone being downloaded. Wow. At a recent deposition, when Unified Command Jerry Holman was asked about how the defense could obtain any information about the second interview, Holman said he had no idea, but encouraged the defense to reach out to the Logansport Police Department to find out. Again, this is according to Holman's deposition, page 5, lines 20 through 25, and page 26, lines 1 through 2. The defense is not required to locate exculpatory evidence or potentially useful evidence of third-party suspects. That is the requirement of law enforcement. Also, at said May 2nd, 2024 deposition, Brad Holder told a third different story concerning how many times he had met Abigail Williams, 2 times, and that one of Brad Holder's meetings with Abby Williams took place at Patrick Westfall's house. What? Oh my goodness, for real? I don't know. I'm not sure if I completely, I don't know. I might buy that. I might, because, if Patrick Westfall was telling the truth that Brad Holder would come and stay with him on the weekends and bring his son or whatever, I could see, because Westfall did talk about how like Logan would go hang out like at the park and stuff like that. You know what I mean? It's very easily that the girls could have possibly met Logan at the park. and, like walked back, maybe over to Westfall's house or whatever, hanging out. You know how like young preteen kids do. You see it all the time. But then, like, I don't know. It just, you never know. Or could it be that Brad Holder knows like they're onto him and he's like, forget it. I'm just going to bring Westfall in this for I don't know, distraction, deflection, deterrent. Or he's like, if I'm going down, you're going down with me. I don't know. Possibly. But, okay, so he says that he met Abby at Patrick Westfall's house. When Jerry Holman was confronted with Brad Holder's ever-changing story concerning how many times Brad Holder met Abby Williams, Holman stated, perfectly reasonable, in my opinion, that he remembered somebody insignificant. If you've only met them twice, you may not remember that. So I don't see exactly what you're asking me. This is Holman's deposition, page 4, line 1 through 15, emphasis added. Well, sir, I'm sorry, and I don't mean to be like, the rude one of the hour, but I'm pretty sure that, number one, if my son was old enough and he was dating a chick and he had brought her home, how many girls is your son bringing home, number one, at 16? Okay, right? Because Logan Holder was 16 years old. And yeah, teenage boys are a little bit whatever. But not all of them are bringing girls constantly in and out of the revolving door. If you meet a girl, you're going to remember them. Okay? Second of all, I'm pretty sure that if my son brought home a girl and the next thing I know, she went missing in a double homicide, or missing and then ended up dead in a double homicide, I'm pretty sure that I would remember meeting that person. Just saying. So I don't know. I mean, that's a pretty big thing. Like, I don't know. Mom, do you think that you would remember meeting somebody?
Yes.
I mean, even if you met the girl one time and then she turned out to be a victim in a double homicide, honestly, I mean, Abby is somebody, to me personally, who stands out. She has beautiful colored hair. You know what I mean? She has a unique look.
She would have stood out.
She would have stood out.
Meeting her would have stood out in my mind.
Yeah, definitely. In my opinion. Just saying. So, let's see. When Jerry Holman was confronted, the insignificant, and she was not insignificant. When Holman was asked if it were likely that Brad Holder would not remember meeting Abby when Holder was asked 3 days after the murders at his February 17, 2017 interview, but then 7 years later, he would remember meeting Abby twice, Holman responded, possibly, yeah. Holman's deposition, page 4, lines 16 through 21. Holman showed no curiosity nor interest whatsoever about why Holder's stories have changed. His attitude supports an argument which defense will later make in this motion that law enforcement have acted intentionally or in bad faith to conceal evidence to such a degree that they cannot even admit obvious factual inconsistencies that point the finger at third-party suspects. Holy guacamole. Number 36. Patrick Westfall was interviewed on August 17th, 2024, and law enforcement extracted data from Westfall's phone. The phone extraction shows that Westfall's phone had no data prior to August 11th, 2023, which was the day that law enforcement contacted Westfall and asked him to come in to be interviewed 1 week later. Oh boy. In other words, it appears that Patrick Westfall either erased all of the phone data on his phone or purchased a new phone after police contacted him on or about August 11th, 2023. The only data found on Westfall's phone was between August 11th, 2023, on or about when police contacted him, and August 17th, 2023, when he was interviewed. No text, videos, photographs, emails, messages, nor any other data existed on Westfall's phone before the day that police contacted Westfall on August 11th, 2023. My goodness. When Jerry Holman was confronted with the fact that Patrick Holder likely attempted to hide his phone data from the state police, Holman claimed that he found nothing unusual, stating, "People erase things all the time." Holman's deposition, page 8, lines 8 through 11. Later, Holman stated that he found nothing suspicious about Patrick Westfall deleting, concealing his phone data before Westfall's August 17, 2017 interview. And this was according to Holman's deposition, page 9, lines 1 through 3. I'm sorry, but I would totally find that very, very suspect. Like, I'm going to interview you and I go to get your phone and you ain't got nothing on there. Again, Holman's attitude toward third-party suspect Patrick Westfall supports the defense's position that law enforcement has intentionally destroyed evidence or acted in bad faith to have intentionally not provided missing evidence such as Brad Holder's second interview, as well as other items identified in this motion. At his August 30th, 2023 interview, State Trooper David Vito did not even ask Brad Holder if he, Holder, would allow state police to extract data from Holder's phone, even though it is clear that Holder had brought his phone with him to the interview. Number 42. Therefore, it is not known whether Holder similarly hid erased data from his phone, like it appears Westfall hid and erased data from his phone. It certainly is curious as to why Vito did not request Holder's phone data when Holder brought his phone to the August 30th, 2023 interview. It is also curious as to why Vito failed to ask Brad Holder one single question about Elvis Fields. I saw Becky Patty had on her Facebook page that she is so over this circus. My heart goes out to her to know that this investigation has been effed up. My heart goes out to all of the people who are genuinely and truly affected by this situation. It's hard for anybody to have to endure it. It's hard for anybody to have to see this or listen to it. Yeah, it's pretty bad. It is curious as to why Vito failed to ask Brad Holder one single question as to the incriminating statement that Amber Holder attributed to Brad Holder that are detailed in Frank's 1. Vito's failure to ask such important questions to Brad Holder during the August 30th, 2023 interview supports the defense's contention that law enforcement is acting in bad faith. Mimicked crime scene image found on Brad Holder's social media is lost. In addition to Holder's 2017 missing phone extraction and missing evidence of Holder's second interview at the Logansport police station, as well as Holder's taped over first interview from February 17, 2017, another key piece of evidence also missing, the mimicked crime scene photo that was on Brad Holder's social media page. Trooper Purdy viewed this mimicked crime scene image on Brad Holder's social media page sometime in the spring of 2017. This image was marked as Exhibit F in Purdy's depot and discussed on pages 79 through 81. This mimicked crime scene image found on Holder's social media page holds an eerie similarity to the actual crime scene. In the mimicked crime scene image found on Holder's social media page, the bodies of two women appear to be staged, lying on the ground in the woods with branches laid across their bodies. One of the women in the mimicked crime scene image found on Brad Holder's social media page has her arms staged or positioned in a similar manner as one of the victims were staged and positioned in this case. At the time that Trooper Purdy also observed the mimicked crime scene photo on Brad Holder's social media page, the general public did not have knowledge of the appearance of the crime scene. The positioning of the bodies on the grounds in the woods and the branches and sticks were arranged on the bodies. In an April 12, 2017 report from Trooper Ryan Winters, it was learned that the state police also came into possession of said mimic crime scene image through the internet sleuth named Ryan Bouchier. Bouchier alerted Winters to the disconcerting images on Brad Holder's social media page and then sent the said images to Trooper Winters over the internet. On April 12, 2017, Trooper Winters then shared with Jerry Holman his knowledge of the mimicked crime scene images found on Holder's social media page and other information. Because of the similarities between the image that Bouchier sent Trooper Winters from Brad Holder's social media account and the crime scene, Trooper Winters requested that Brad Holder be re-interviewed. Despite that request, state police ignored Trooper Winters and never re-interviewed Brad Holder. Brad Holder was only interviewed in August of 2023 after Jerry Holman was challenged by the defense to reopen the Brad Holder investigation. To this day, the prosecution has failed to turn over the mimicked crime scene image that Purdy found on Holder's social media in 2017. Dang. That's heavy. So the prosecution hasn't even turned that image over. Brad Holder's phone records, they said that they don't have his second interview. Let's see. Brad says, I didn't meet Abby. Then I met Abby at Patrick Westfall's house. Man, this is just insane. Fortunately, because the internet sleuth Bouchier had saved the image that he turned over to Trooper Winters, the defense was able to drive to Georgia and retrieve that image. When deposed, Trooper Winters claimed that the state police could not access the image that Bouchier found on Holder's social media, that Bouchier then turned over to the state police. Winter deposition, August 23rd, 2023, page 29, lines 20 through 23. How could the state police lose such an important piece of evidence as an image found on a suspect's social media that mimics the crime scene? The defense again would proffer that the mimicked crime scene photo was not lost. Logic and common sense dictates that such an important piece of evidence would not be lost by the state. The defense is filing simultaneously here within its memorandum in support of its second motion to dismiss based upon newly discovered, destroyed, and or missing exculpatory evidence. As detailed in said memorandum, if the defense can show that the missing evidence is exculpatory in nature, then the defense does not need to show that the missing evidence was intentionally destroyed. If, on the other hand, the defense cannot show that the missing evidence was exculpatory in nature, but can show that the missing evidence is potentially useful evidence, then the motion to dismiss should still be granted if the defense can show that the law enforcement intentionally or acted in bad faith regarding the destroyed or missing evidence. The exculpatory nature of missing evidence. Currently, the list of missing evidence that the prosecution has not turned over to the defense includes the following. A. Video of Brad Holder's first interview from February 17th, 2017. B. Video of Logan Holder's interview from February 17th, 2017. C. Data from Brad Holder's phone extraction from February 17th, 2017. D. Video from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. E. Audio taken from Brad Holder's second interview with law enforcement taken at the Logansport police station sometime in 2017 or 2018. F. Any reports, notes, or documents concerning or referring to Brad Holder's second interview at the Logansport police station sometime in 2017 or 2018. G. Mimicked crime scene photos observed by Trooper Purdy on Brad Holder's social media page. H. Images Ryan Bouchier sent to Trooper Winters on April 12th, 2017. Give me just a moment. Okie dokie, Bishoki. So let's see. So we got through the images Ryan Bouchier sent to Trooper Winters on April 12th, 2017. Notice that all missing items are related to third-party suspect Brad Holder. Also note that the prosecution is asking that the defense not be allowed to even mention the name Brad Holder during trial. Currently, the list of evidence that the prosecution failed to turn over to the defense until the defense requested the prosecution to turn it over, or upon the prosecution's realization that the defense would soon be learning about the existence of said evidence, includes A. Todd Click's letter and accompanying 85-page report. The prosecutor held on to this evidence for over 4 months until he knew that the defense would learn of its existence. B. Multiple Elvis Fields interviews. C. Rod Abrams interviews. D. Multiple Johnny Messer interviews. E. Multiple Taylor Hornaday interviews. F. Ned Smith interview. G. Libby German phone dump. Wow. 70. Notice that all items A through G in paragraph 69 above are related to a third party suspects and Odinism. Also note that the prosecution is asking that the defense not be allowed to even mention any of these third-party suspects or Odinism during trial. The evidence that the defense does have in its possession showcases that on multiple occasions, third-party suspect Brad Holder has changed his answer concerning a very basic question. How many times has he met Abigail Williams? According to the only police report that memorialized Brad Holder's accidentally destroyed first interview, Holder stated that he had never met Abby Williams. At the time, he was first approached by law enforcement, February 17, 2017, and asked the question, "How many times did you meet Abby Williams?" Common sense would dictate that the answer would be fresh in Brad Holder's mind and easy to detail because of A, the proximity in time that Brad Holder's son dated Abby Williams. Logan Holder was dating Abby Williams at the time of the murders. And B, the enormity of the situation, i.e., 2 girls had been murdered, one of whom dated Brad Holder's son. If Brad Holder is in any way involved in the murders, as the defense believes the evidence strongly supports, then Brad Holder's claim close in time to the murders that he never met Abby Williams is understandable. Denying that he, Brad Holder, had ever even met Abby Williams could, in Holder's mind at least, cause the police to take their attention off of Holder. If at this February 17th, 2017 interview, Holder was telling the truth that he never met Abby Williams, then his answer to police when asked the same question even 6.5 years later on August 30th, 2023, should easily be the same. I never met her. But a father would definitely remember if he ever had met his son's girlfriend who had been murdered. Conversely, a father would know if he had never met the murdered girlfriend of his son involved in a high-profile case. If I were the parents of those girls, I would be so pissed and so sad. Yes, definitely. Like the whole thing just makes your blood boil. Let's see. At his August 30th, 2023 interview, Brad Holder's story changed. Now he claimed that, in fact, he had met Abby Williams one time. Either Brad Holder intentionally lied to police in 2017, closer in time to when Logan dated Abby, or Brad Holder had simply forgotten his meeting with Abby Williams, but then somehow remembered the meeting 6.5 years later. Then, at this May 2nd, 2024 deposition, Brad Holder provided yet a third different answer. He actually had met Abby Williams 2 times. What? Furthermore, at his May 2nd, 2023 deposition, Holder remembered that one of those meetings occurred at Patrick Westfall's house. Holder's deposition, page 20 through 21. Right, Adrian? That is absolutely crazy. Not to get those phones is absolutely unbelievably ridiculous. I mean, I would have, they should have got those phones, literally. They should have got them. It is 100% nuts. Let's see. Brad Holder's ever-changing answers to such a simple question provides evidence that the missing items, A through H, detailed in paragraph 66, are exculpatory in nature. When combined with the evidence contained on Brad Holder's social media pages, including images of runes inked onto Holder's hands that mimic the way sticks were formed on Abby's body, as well as all of the other evidence detailed in Frank's one, the ever-changing stories of Brad Holder on this simple topic of how many times did you meet Abby Williams should all provide insight as to why the defense believes that the missing evidence contained obviously exculpatory evidence. How could it not? It would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why many missing items would contain obvious exculpatory evidence. The picture on his hand looks just like the sticks on Abby. Have you seen it at Dark Arts, Adrian? Fluffy Bunny's asking. If you haven't, Adrian, let me know. I do have a snag of it when it was posted on Facebook. I also have a snag. I have the photo that he had painted too that they talk about in it. I was able to snag that up too. You have seen it. Okay, awesome sauce. Let's see. It would be impossible for the defense to show that the missing evidence contains clearly exculpatory evidence. Therefore, the defense is left with providing circumstantial evidence along with logic, reason, and common sense as to why the missing items would contain obvious exculpatory evidence. The defense believes that it has showed that the missing destroyed evidence is exculpatory in nature. The missing destroyed evidence is exculpatory, but even if the court disagrees, the court should find the missing destroyed evidence as potentially useful and dismiss charges. I haven't seen the photo mimicking the scene. Do you have that? I have the one, it's painted. It depicts kind of like the Hanged Man tarot card. If that makes any sense, that's one that I have. So glad there are quick people to get those screenshots. It's so important. Oh my gosh. Those screenshots, I have been sitting on them for like forever, like just sitting around. You have that one. I've got some other ones too. Like I was going through my photos this morning. Like I have a whole bunch of stuff. I think only the Bouchier grab has the art of the woman in the woods. I think so. Well, it did kind of float around for a second, but then it disappeared. Like it used to be on there. And I don't know if I still have it or not. It's Odin on the Tree at Dark Arts by Adrian that he painted himself. If you haven't seen it, yeah, it's a really an interesting one. Where they are laid out similarly to the crime scene. Yeah. There was, I want to say that one was painted too. Yeah, that the painted women. I will have to look through my photos. I'm pretty sure I might have it. Because I know that I have the Hanged Man one. I also have the one, hold on. My goodness gracious, great balls of fire. Can I sell my husband for medical experiments? I told him, I was like, I'm live. And then he calls back And I was like, I'm still live. And he's like, still? I was like, yeah. And he's like, well, how am I supposed to know? Use your text messaging, my love. Use your text messaging. Yeah, I will look through my photos and stuff. I'm pretty sure like I have a lot of stuff. Um but yeah, I can look and I can let you know. Um the missing destroyed evidence is exculpatory. I have an understanding husband. Some days it depends on the day sometimes. Sometimes he's really patient, and other times he's not. Um, Normally, like, I usually try to do my lives while he's gone at work so that, like, when he's home in the evenings, like, I'm able to take care of stuff because he doesn't really like me doing them at night. It's part of the reason why I didn't go live last night is because I have to wait until I have the, calming down your hubbies. Yeah. What was I going to say? Okay. So the missing destroyed evidence is exculpatory, but even if the court disagree, the court shall find the missing destroyed evidence as potentially useful and dismiss charges. As detailed in the accompanying memorandum, if this court finds that the missing destroyed evidence is not exculpatory, but does find that it is potentially useful, then the court should dismiss charges if it also finds that law enforcement intentionally caused the potentially useful evidence to be destroyed or acted in bad faith regarding the missing evidence. My hubby is always like, I need your help right when I'm doing something important. That's how my hubby is. That's exactly how my hubby is. I could be doing nothing at all, not doing anything, and he doesn't need anything. But as soon as I'm in the middle of doing something, he's like, it's time to get the wife to do it. Yeah. Oh my gosh. I am so laughing at that. Franks 1 through 4 provide many details of why this court should believe that law enforcement intentionally caused the potentially useful evidence detailed herein to be destroyed and acted in bad faith. The defense incorporates the contents of Franks 1 through 4 in this motion. Provided below are a few facts that support the defense's contention that law enforcement has acted in bad faith or intentionally lost or destroyed evidence or have failed to turn over said evidence to the defense. A. Missing portions of vital video from Jerry Holman's 10/26/22 interrogation of Richard Allen. Jerry Holman interrogated Richard Allen on October 26, 2022, and said interrogation was videotaped. Hey, Aaron. Sorry to have missed so much. Head was in Canton. It's okay. It's all right. We're moving along. We're on page 12, the end of page 12 of 20 of the second motion to dismiss. However, the first few minutes of the interrogation are inexplicably missing. What is it with things like going missing, like you or not there? Because like even at the March 18th hearing, when they talked about like the videos that they said were gone off of this 6 terabyte hard drive, they had gotten this like Chinese program to extract it. And all they were able to see was like video. Like they could see somebody there, but they couldn't hear anything, no audio. So we're looking at a pattern. Like you have no interviews at all for Carroll County, right? For the Delphi Police Department. You did a second interview with Brad Holder at the Logansport Police Department. That goes AWOL. And then this one, the first few minutes of the interrogation are inexplicably missing? What is it with you guys? The missing portions of the video, according to Jerry Holman, would have shown Holman discussing Richard Allen's Miranda rights and freedom to leave the room, both important concepts that might support the legality or illegality of Holman's interrogation. So basically what you're saying is that there could be a possibility that you did or did not Mirandize this gentleman upon his detainment, but we'll never know because the portion you claim is missing is the portion for the Mirandization. But how do we know that that actually came from the Mirandization of Richard Allen? How do we know that you didn't just take the ending of the previous interview that was on the recordings in question, erase a few minutes of that, and make it look like it seamlessly lodged into the interview with Richard Allen? Fluffy Bunny, that Chinese software was a joke. They had the FBI helping them. Why didn't they ask them? They had every opportunity to ask the FBI. You're right. Exactly. But I don't know. Like, if it was me and I had the FBI helping, I mean, think about that. They had 3-letter agencies. How many 3-letter agencies do we have in the United States? We have 438 of them. And there was a lot of agencies that were involved in this case, not just FBI. Like, you had Homeland Security, you had what is that? The sheriff that goes across the United States, the marshals, the U.S. Marshals or whatever. They had so much more than that helping them. They had access to a lot of technology. And yeah, they just flushed it down the tubes. No explanation exists as to why only the portion of the videotaped interrogation that is missing is crucial beginning to the interrogation. The missing video supports the defense contention that Holman knew he was screwed up and therefore edited out the first few minutes of the interrogation to avoid the statement being suppressed. The missing video from Holman's October 26th interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. Dark Arts by Adrian. Wow, I had no idea there were so many, right? Yeah, there are. Like, it's crazy because I was wondering myself, so I started Googling it and I pulled it up. We have 438 agencies here in the United States. Each of them are sectioned under different, like they do different things. Like each one does handles different things. But yeah, it's really interesting. I can share it on the community page if you want to see the list, just for, if you're interested, I can do that. So the missing video from Holman's October 26th interrogation of Richard Allen is evidence of intentionality of law enforcement involving the concealment or destruction of evidence and or evidence of bad faith. Jerry Holman lied in his August 10th, 2023 deposition that Brad Holder was never a suspect. In his August 10th, 2023 deposition, when asked if Brad Holder was ever a suspect, Holman said the following: "Not really, no." This is according to Holman's deposition, page 172, lines 4 and 5. However, it is clear from reviewing emails between Doug Carter and the FBI that Brad Holder was a suspect very early on in this case. As stated before, Holder was thought to be a suspect and his name was known as a suspect even at the highest level of the state police superintendent, Doug Carter, and even known to the Indianapolis top FBI agent, Jay Abbott. The fact that Holman misled the defense by claiming that Holder was not really a suspect is evidence of the intentionality of law enforcement involving the concealment of evidence and/or evidence of bad faith. The prosecution failed to turn over the Todd Click exculpatory evidence for 4 months, and then not only turned it over after it was obvious to the defense would be soon learning of its existence of Click's letter. As detailed in Frank's 1 and numerous other pleadings, the prosecution chose not to turn over exculpatory evidence from May 1st, 2023 until September 8th of 2023 of a letter from Todd Click and 85 pages detailing his investigation. Contained in the Click letter was evidence that 3 law enforcement officers who investigated the case believed that third-party suspects, Brad Holder, Patrick Westfall, and Elvis Fields, were involved in the murders, and Click's belief that the evidence supporting their involvement in the murders was much more compelling than the evidence against Richard Allen. As stated in a previous pleading, it is hard to believe that a much stronger example of exculpatory evidence could exist than documentation that 3 law enforcement officers essentially believe that the wrong man may have been arrested. The fact that the prosecution refused to not immediately turn over the exculpatory Click letter for over 4 months is evidence of the intentionality of law enforcement involving the concealment of evidence and/or evidence of bad faith. The prosecution failed to turn over exculpatory evidence contained in several videotaped statements until after the prosecution knew that the defense would soon learn of their existence. As detailed earlier in this motion and in Frank's 1, the prosecutor failed to turn over several videotaped interviews that provide exculpatory evidence concerning third-party suspects until after it was clear that the defense would soon be learning of the existence of those videotaped interviews. The prosecutor turned over these videotaped interviews nearly 9 months later than required under rule and statute. Those videotaped interviews provided exculpatory evidence in terms of blown alibis of third-party suspects, as well as connectivity between third-party suspects and also provable lies told by third-party suspects concerning their knowledge of other third-party suspects. The fact that the prosecution failed to turn over exculpatory evidence that supports the involvement of third-party suspects in committing the murders until after the defense would soon learn of their existence is evidence of intentionality of law enforcement involving the concealment of evidence and/or evidence of bad faith. The prosecution and law enforcement attempted to conceal the identity of Purdue professor whose testimony contradicted the sworn statement of Jerry Holman. This matter has been detailed in Frank's 1, 2, and 3, and in the various other pleadings previously filed. At his August 10th, 2023 deposition, Jerry Holman stated under oath that part of the reason that law enforcement ruled out the persons practicing Odinism or some type of cult had committed the murders was because a Purdue professor ruled out such a possibility. Holman, August 10th, 2023, deposition page 63, lines 7 through 20. However, after reviewing the Purdue professor's report prepared on or about March 1st, 2017, as well as listening to the Purdue professor's September 19th, 2023 interview, it was determined that the Purdue professor never made such a claim as Jerry Holman stated in his Holman's deposition. Furthermore, at his deposition, the Purdue professor, Jeffrey Turco, specifically denied that he had ever made the very statement that Holman attributed to Turco. Turco's deposition, page 65, lines 7 through 25, and page 79, lines 18 through 25. Additionally, the prosecution told the defense in a September 6, 2023 email that the identity of the Purdue professor was still unknown and may not ever be able to be found. This was untrue, as Jerry Holman had already learned of Jeffrey Turco's name weeks earlier. Additionally, the defense learned that the actual Purdue report from March 1st, 2017, which also contradicted Holman's deposition testimony, was in possession of law enforcement since that time, but was purportedly rediscovered by law enforcement in August of 2023. The prosecution finally produced said report to the defense on October 4th, 2023, and only upon request of the defense. So rediscovered in August of 2023. Was this like during your whole, like, we're going to keep going and combing through all of the evidence? We're going to go through it, get through the end of it, and go back and go over it again and again and again and again? Seems like you guys missed a lot of things combing and recombing through evidence for a while. Jerry Holman's August 10th, 2023 deposition testimony was false concerning the findings of the Purdue professor, and therefore his testimony is evidence of law enforcement's intentionality in attempting to conceal evidence and or evidence of bad faith. The attempt of law enforcement and the prosecutor to conceal the identity of the Purdue professor is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. The prosecution failed to turn over one of the key pieces of evidence for nearly 9 months, and then only after the defense kept requesting the prosecution for the same. A key piece of evidence in this case is the phone data extracted from victim Liberty German's phone. The prosecution and law enforcement had possessed that evidence for 5 years prior to Richard Allen's arrest, and therefore should have been able to provide that evidence immediately to the defense. However, the defense did not receive that evidence until September 8th, 2023. Almost 9 months later than required under criminal rule. After the defense had a chance to review said data from the phone, it was determined that exculpatory evidence existed in the phone that did not support law enforcement's timeline and supports that third-party suspects were involved in the murders. The failure of law enforcement to turn over Liberty German's phone for nearly 9 months, thereby concealing exculpatory evidence the defense could have been exploring, from the beginning of their representation, is further evidence of intentionally and attempting to conceal evidence and or evidence of bad faith. If I were the family of both girls, I would be screaming from the rooftops, right? I got you, Altera. Law enforcement concealed the Blocher report until April 26, 2024. On April 26, 2024, the state of Indiana turned over a report from Steve Mullen concerning the findings of Sergeant Mitch Blocher of the Indiana State Police. Contained in the body of that report was exculpatory information concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017. What? Contained in the body of that report was exculpatory information concerning ping information that supports that on February 13th, 2017, the victims were not located at the same scene as they were found on February 14th, 2017. The failure of law enforcement in turning over this report for well over 1 year beyond when the prosecution was required to turn it over, and not after the defense sent a certified letter and filed a motion to compel for sanctions, demanding that the prosecutor turn over certain evidence, is further evidence of intentionality in attempting to conceal evidence and or evidence of bad faith. Tobe Lesenby contradicted the sworn statements of both Jerry Holman and Tony Liggett concerning the number of people involved in the murders. This matter is detailed in Franks 1. Both Liggett and Holman testified under oath that only one person, Richard Allen, was involved in the murder of the victims. This proclamation under oath by Liggett and Holman would negate the defense's contention that evidence supports that multiple people involved in Odinism were involved in the murders. However, when Tobe Lesenby was deposed, Lesenby, stated under oath that Tony Liggett actually believed that multiple people were involved in the murders. So, Dark Arts by Adrian Altera says, what? The girls were not there. Where were they? I think they're referring to, okay, so remember the document that got released the other day that we read about the pings, right? So instead of getting the location of the girls by live pings, they didn't have the live pings. So they were using the historical data to start with, right? To try to pinpoint where they were at. I think that's what they're referring to, is like the historical data pings. I think that that's what they're referring to. I'm not going to say for sure. We may have to ask somebody about that, because somebody knows more about that than I do. But I believe that that's what they're referring to, is that like the historical pings, when they started pinging the girls from where the phone initially was, it was not in the same spot that the girls' bodies were found. Dark Arts by Adrian said, if this wasn't so rigged, there would be really no legal means of holding Allen in custody, in my non-lawyer opinion. I second that. Absolutely, I second that. Because looking at this, as I said in the first place, when you look at this probable cause affidavit, I'm looking at it, and to me, this is certainly not enough to have somebody sitting here for this long. Just like the other day, again, when it was pointed out in the prosecutor's filing about how the girls were kidnapped and taken to this place before their lives were taken. I mean, can he still use the shtick that they were kidnapped when Richard Allen couldn't be legally charged with kidnapping because the statute of limitations had elapsed that 5 years? Does that make any sense? I don't know. Okay, that makes sense. I hope the family is asking questions. It seems the wool was pulled over their eyes. There's a lot of stuff going on here. A lot. So I'm wondering, that's a great point, Mama. Yes. And so, I'm wondering, okay, number one, you couldn't really charge him with kidnapping because the statute of limitation had fallen off. And that's why he got anteed up to those higher class of murder charges, right? So if he couldn't be charged with kidnapping, but you could get murder, the charge of murder in commission of a crime such as kidnapping, I wonder how that works. I don't know. It's something to ponder. But yeah. So what was Okay, no recordings of Richard Allen's interview with Dan Doolin exists. In 2017, Dan Doolin has stated that Doolin, knew that he had audio recorded interviews when conducting interviews of tips and leads. This is according to Doolin's deposition, page 55, lines 18 through 25. Doolin claims that he now believes that he never audio recorded his interview of Richard Allen. I think I must not have audio recorded it because all of the other ones that I had are in a file on my computer. And I listened to each of them just in case they were mislabeled. Every audio recording I have, and none of them was Mr. Allen. This came from Doolin's deposition, page 56, lines 2 through 9. This interview is crucial as what Doolin claims Allen told him. Doolin helped establish the timeline used to secure a search warrant and to arrest Allen. The defense believes that Richard Allen was tape recorded and that the missing tape supports intentionally on the part of law enforcement and or evidence of bad faith. Missing mimicked crime scene image. This was detailed earlier in this motion and in Frank's one. The fact that this incredibly exculpatory piece of evidence cannot be accessed and therefore is still missing, causing them to travel to Georgia to obtain said image, is evidence of intentionality on the part of law enforcement to conceal exculpatory evidence and or evidence of bad faith. Brad Holder is a key third-party suspect, yet Jerry Holman denied that fact, and then law enforcement failed to turn over multiple pieces of evidence that support Holder's involvement, along with other third-party suspects identified in Frank's one. Furthermore, law enforcement have claimed that Brad Holder's initial interview was taped over. Furthermore, law enforcement claims apparently that they never extracted data from Brad Holder's phone when they extracted data from at least 101 other phones from people who weren't even suspects like Holder. Furthermore, law enforcement claims apparently that they never extracted data from Brad Holder's phone when they extracted data from Logan Holder's phone, which was turned over to the police at the exact time that Holder turned over his phone. So little Holder turned over his phone the same time as Big Holder. They took little Holder's information, not Big Holder. Furthermore, law enforcement has turned over zero evidence of Brad Holder's second interview conducted at the Logansport police station, and the defense only learned of said interview through a deposition of Brad Holder conducted on May 2nd, 2024. Furthermore, law enforcement claimed that they cannot access the mimicked crime scene photo that was on Brad Holder's social media page. All of the issues of missing evidence surround one person, Brad Holder, and Odinism, which the prosecution is also attempting to block the defense from even mentioning at trial. Richard Allen cannot have a fair trial when exculpatory evidence that would support the involvement of third-party suspects is missing. Only so many coincidences can explain away why so much evidence concerning Brad Holder and Odinism is still missing, and why the prosecution failed to turn over much of the evidence that the defense does in fact possess concerning third-party suspects for 9 months or more, and only after the prosecution knew that the defense would soon be learning of the existence of that third-party suspect's evidence. The bad faith of law enforcement and prosecution has been proven through these numerous examples of missing evidence and evidence that the prosecution failed to turn over to the defense in a timely manner. Because the missing evidence is exculpatory in nature, the charges against Richard Allen should be dismissed. Even if the court finds the missing evidence is not exculpatory, it is clearly potentially useful evidence, and the numerous examples of bad faith contained in this motion require that charges against Richard Allen be dismissed. Wherefore, pursuant to the law detailed in this memorandum in support of this motion, as well as the facts contained in this motion, the defense requests courts to dismiss all charges against Richard Allen. Respectfully submitted, Andrew Baldwin. Oh my goodness gracious, great balls of fire. Whew. So what do you guys think? Like, that was a mouthful, a big mouthful. Crime Chronicle Hub. There's a lot of reasons why Richard should never have been arrested. Search warrant, chain of custody, his Miranda rights not being read to him. Yes, absolutely. There's a lot of reasons, a lot of things. Like, this should not have even gone as far as it has gone. And it just keeps continuing to grow legs. It doesn't make any sense to me at all whatsoever. So maybe do you guys might want to have a discussion at all? I could throw like a link and we can come up here and talk about what we just read if you'd like. I don't know. Perhaps why Diener resigned. Yeah. Well, I think Diener knew what was coming down the line, honestly. I don't know. Like, I think that he saw some things there. And then considering that he also had handled like the estate issues, I don't know if maybe he was able to get out of it because it was said conflict of interest or what. But I suspect that Diener knew that there was something coming down the line, and he knew that he did not want to be included in that. Exactly. They did not have grounds to hold him. No, they did not. I like to hear a discussion. I'm too shy to come up. Maybe Adrian will. Oh, fluffy bunny. I will put the link here. And you don't have to, but if you want to come in, you can. Kaboom, defense is right, but Goal will deny this motion too. In a way, that's a good thing. The case will not just go away quietly. But the smartest thing, the most clever thing about this motion for the defense's motion to recuse, okay? Let's talk about how smart this was. Not only can she not rule on anything else on the docket until she addresses this situation first, but this is the perfect opportunity to show bias, because the defense has requested that she be required to give a written reason with said yes or no to doing this recusal thing, right? So she says, no, I'm not going to recuse myself. I'm going to keep it moving and I'm going to keep it pushing. You're just going to have to deal with what you have to deal with. Then she's got to give a reason behind that. And this could be the edge, like the extra that they need, like right now, to go ahead and file that third original action that Mr. Osbrook had mentioned. Who knows? That's a cover up because they know what he actually says in the recording contradicts what they put in document the PCA. Yeah. Too tired to participate in this stream, but let's try to make it happen at some later date. We can do that. But yeah, so I think that this is all just insane. And I was looking at um some other filings earlier. Like I was looking at like the list of like all of the evidence that had been turned over um to the defense on the certain dates and how much it was, and then to look at this this last hearing um at the March 18th hearing, when they're talking about all of this new evidence that's like being dropped on them. And like that cutoff was long ago, supposed to have been come. But it's crazy to me how it's still coming, and there's no sanctions like put against anybody so far for stuff coming out late. I mean, I don't know. I'm really hoping that the Supreme Court, like if they have to go back before the Supreme Court and they are able to get the approval to take out that third original action, like I said before, I don't think that the Supreme Court is going to be too thrilled with the fact that this is going on. And I don't think that they will be thrilled that, this keeps happening. I can't understand how they keep finding new evidence to hand over, right? Hi, Adrian.
Hey Mama, how you doing? Can you hear me okay?
I can hear you great. Oh my goodness. Great,
Yeah.
great, great.
Awesome.
I'm so glad. I saw your live this morning and I literally had just finished it like right before I started my live. And I was like, that's awesome.
Oh yeah. I was like, can somebody help me understand this?
Yeah,
But yeah, I
it's
don't
a
know.
lot. It's a lot, especially like when you don't, for somebody who might not um see something like this every day,
Right.
read something like this every day. It's a
Yeah.
lot. Like it's a slap in the face sometimes.
Oh my gosh.
Oh,
And it's just like, how could it even, like you were saying, your chat was saying, how could it even have gotten this far?
there's no way it should have. There's no way it should have ever gotten this far at
Mm,
all. I don't I
yeah.
don't understand it.
Yeah.
I just don't.
Hopefully you weren't one of the people that went down to Carroll County for the, I guess like content creators had gone out there to wait for the 3-day thing that then got canceled.
I only live 2 hours away, so I don't have to drive down there
Oh
in any
yeah, okay.
crazy form or fashion.
Yeah.
Yesterday, when I found out that they were canceling the hearings and all that stuff, I just decided I wasn't even going to take the time to drive to that area.
Oh, that's good.
Gonna stay
Yeah,
home.
good.
Um, Otherwise, like if they would have had something popping off today, yeah, I would have been there. Um,
Yeah.
and like I was actually kind of like excited to go out there and to listen to what they had going on today. I was a little bit concerned about how the motion in limine was going to go because they're still in the process of deposing certain
Oh,
individuals for
okay.
dates going on, like the psychologist, Dr. Monica Walla. They're not done deposing her either.
Oh,
Like
wow.
they're still deposing her. I know that they have deposed Holman, Beto, um, obviously Brad Holder, like some of the people that were on the Delphi homicide,
Okay.
unified command. Um,
Yeah.
they were getting her, the doctor, and then something else that they had mentioned.
What?
Somebody else that they were going to depose. They were trying to get all of that information together.
Okay. What is the lemonade thing?
Motion in limine. Okay,
Mhm.
so a motion in limine is basically like a mini trial within a trial. It's like the
Oh,
preview of what you're going to see when the main trial comes to forefront. So what
okay.
happens in a motion in limine is that the prosecution and the defense go before the judge, and the prosecution says, "Hey, judge, These are things that I think that the defense should be able to use and should not be able to use. And the defense can do the same thing, vice versa. So they
Okay.
hash out their arguments to begin with to decide, okay, you can use this part of the discovery in the case, or no, you cannot use this part of the discovery in the case unless something else is introduced into evidence that
Oh,
opens the door to
right.
be able to circumvent that other evidence.
Okay, so was that when the judge said the nexus thing in the email, is that what this 3-day thing was going to determine if there was a nexus so they could talk about the third parties?
Um, I don't know. I think okay, so the nexus thing is basically tying them criminally to it.
Oh, okay.
So
Okay.
a nexus is like a criminal background check. Hold
Oh,
on one
okay.
second. Crime Chronicle Hub. We can plan it. Crime Grit. I'll talk with you if we can schedule it. Yeah, definitely. We can schedule a live to do together. Email me at truegritcrime@gmail.com. And if you leave your email in the comments, like vice versa, we can set something up. But yeah,
Uh-huh.
so basically the nexus would be like the third party nexus would be showing the people who are like related to this and how their relation to this crime would be. So like they would have to show how they believe that Brad Holder, Patrick Westfall, Elvis Fields, Johnny Messer, all of those other people that have been named, they would have to show exactly how they got to that point. Another thing that I noticed this morning that
Mhm.
I don't know, like I was looking up all of like the different information that I had stored, but there's a
Uh-huh.
last name that is like interconnected to more than one person to do
Oh,
with all of this.
yeah.
Huddleston.
Huddleston. Okay.
Huddleston.
I haven't heard that name. How
Um,
is okay.
I'll
I mean,
have
I haven't read through everything either. I usually like I have to like hear it from somebody like you or Teresa from
to.
Criminality to like understand it, and then I have to like go over it several times. But um,
Yeah.
so
Rick
yeah,
Rick Huddleston is a name that's come up. Like,
Rick Huddleston. Okay.
and it's somebody that's been mentioned by more than one person along the way, but there are um, relations. Like,
Oh, gotcha.
so there's a family member that is related to him,
Okay.
by marriage, but
Okay.
one of the suspects is also somehow related by marriage.
Oh, wow.
I don't think that they recognize that, but one of the main suspects that they talked about in this document
Wow.
is with somebody who is a direct relation to the Huddleston family.
Wow. Oh my,
Crazy. And I saw that this morning and I was like, what?
what?
How did I totally like miss
Oh.
that? Like, how did that? It was like a 747. Yeah. Like, wait a minute.
But I mean, like, how I ask, like, how do I miss things all the time? But it's like, well, because we're getting whiplash, like, with every new little thing that comes out, because it's just so much more information and evidence that we've gotten at any other time. And then, you try to go down those rabbit holes, and pretty soon you're in like a web of rabbit holes, and
Well,
you know.
yeah, you're definitely in a web of rabbit holes, but I think that after so many years of no formal word except for a couple press
Hmm.
conferences here and there, and somebody being like, "Oh, well, you know, this rumor is going on, this rumor is going on," you didn't hear anything for a long time.
Right.
So, of course, it's like people are just like,
I
because
know.
everything is being dropped on them at one time.
Right. It's
And then
just, yeah.
it's not even just the dropping of the documents at one time, but while like the documents are dropping, and then you've got like all of these other things going on in the sideline views to deflect your
Uh-huh.
attention, like for
Yeah.
example, okay, if anybody has noticed, like, okay, I covered the Mitchell Westerman hearings as well. Some of these hearings have been like rescheduled to be scheduled on the same day that things are going on with Richard Allen.
Of
You know what I mean?
course.
So like
Yeah.
the day like you're going to the Scoyne hearing, right?
Oh,
Like
yeah.
I caught his first hearing the
Oh,
day that
wow.
the Scoyne hearing was going on. I went down, I got my ticket for the Scoyne hearing. I left out
Uh-huh.
of there. I went over to drive 40 something minutes to go see the Westerman hearing and then drove back to go see the Scoyne hearing. The next time
Wow.
that he had a court date, it was scheduled on one of the days that Richard Allen was scheduled on. Then like his court date gets scheduled and they like keep scheduling around each other because
Uh,
Westerman's judge wants to know what's going on with Delphi,
yeah.
you
Yeah.
know,
That's a
before
good
they do
judge.
anything else, which is absolutely understandable,
Right.
you know.
Holy crap. I need to
So
watch your stuff then on the Westerman.
yeah. And see, the next hearing for Westerman is going to be in June.
In
So
June.
I think
Okay.
it's June 23rd. I'm gonna look it up real quick
Wow.
because I will be going to those hearings as well. I
Yeah.
also want to catch the Shane Meehan hearings that have to do with the Greg Ferentz.
Yeah. Dude, because that's been so undercover.
Yes, all of it has. And like I said, this isn't just like, okay, so like unfortunately the fact of the matter is that yes, the people that are allegedly involved in the commission of the crime are involved in other secondary groups.
Oh,
So
yeah.
that's how, because of their involvement with those groups and because those groups are being looked at as forms of anti-terrorism or
Yeah.
terrorism by
Yeah.
the FBI, that is how these cases bumped up to back up to each other.
Wow. Well, do you have any law enforcement friends that could go with you?
I'm sorry, what?
Do you have any law enforcement friends that could go with you?
I do have some law enforcement people that I guess I could get to go with me, but I mean, I really don't have to because I'm not really too much worried about it, quite frankly.
Okay, that's good. That's
They,
good.
they ain't gonna do anything to me. They don't have nothing on me. They
Yeah.
won't have anything on me. So I'm not worried about it.
Yeah. I guess I just get so paranoid because Alan looks so normal and he had such a normal family life,
You
and
know, it's crazy to me because, like, when I first started going to the hearings, like I said, it was after that June hearing,
Mhm.
the June 15th hearing where they had the uh, warden, coming out and giving his testimony. And
Yeah.
June 25th at 8:30 a.m. is the Westerman's next hearing.
Okay. Okay.
Because he had a session that had gotten rescheduled that was for the 14th of this month, and they rescheduled that. So,
Wow.
so yeah, so I, what was I saying?
We were talking about the not Westerman, but the Rick Allen, maybe that he looks so normal and stuff.
Oh, well, now he looks a lot better. That's right. So
Yeah.
like when I had started going to the hearings, like the next hearing I went to was after that June 15th hearing. Because I
Okay.
was sitting here, like, and I was watching people who had gone to the hearing, who had talked about going to the hearing and stuff like that. And
Mhm.
then as I was listening to what had apparently had transpired in the hearing and then watching media, I'm like, there's different things coming and that doesn't make sense. There's something wrong here.
Yeah.
I looked at my mom. I was like, there's just something just off.
Yeah.
And so I said, I need to start going to these hearings. And so I decided, because like I had already been, on the Delphi case, exploring it, sleuthing it. I'd been
Mhm.
out there several times into the area, into the terrain, trying to see like everything about it.
Yeah.
And when my husband came home that day, I was like, listen, I've tried to hold out because I was just going to initially hold out just for trial.
Okay.
But I told him, I said, there's something fishy going on here. And I said, I think I need to go.
You and Bob, then, like, you guys picked up on it because Bob was, he was trying to get the word out, but he was smaller than two. Bob Mata, I should say.
Yeah.
And, you
Bob
know,
Mata is big. Like,
yeah, big
he's
now.
big.
Yeah. And he was still big then, like, as far as podcasting goes, but, like, he felt like he was trying to tell everybody about that June hearing in 2023. And,
Mhm.
like, nobody was really paying attention because he's like, something's not right. You know?
Right. Well,
Yeah.
that's how when I picked up on it, because
Yeah.
when I started, I was like, there's something wrong. I was like, there's no way. And then like it kind of went silent for a little bit. And
Mhm.
then all of a sudden you got that first Frank's memorandum.
Yeah.
And it wasn't even just that. I had been also paying attention to the videos that Brandon Woodhouse had dropped. And I
Oh,
was like,
yeah.
what? And
Yeah.
so I'm watching that and I was like, yeah, no, yeah, no. Then you
Okay.
got the
Yeah.
Frank's memorandum, and I was like, holy guacamole. Like,
Yeah.
this is just all at once. And as I
Like,
started to read it more, I was like, yeah, no, like there is no more of like sitting back and just waiting.
right.
There is no more of that. There's something severely going on.
Right. Yeah.
So yeah. And
Oh,
then when they talked about the Odinism and the white supremacy groups, that really just that right there was enough for me to be like, okay,
yeah.
it's on.
Yeah. Cause like part of me was, like I had worked in a metaphysical shop, and the area that I live in is, it kind of, there's a lot of like MCs, like, the guys, and that a lot of them are into heathenry and that kind of stuff. So
Yeah.
I knew that stuff existed, but I was just kind of like, well, let me look at this, because everybody was like, this is the kookiest thing that's ever been. And once I just started reading a little bit of it, I'm like, this is totally understandable. You
Right.
Like, but if you aren't exposed to it, then maybe you don't understand. But like, if you do, if you even have a glimpse of it, you can tell.
Well, I didn't realize how popular the religion was right
Hmm.
away until um like I don't know, it was like a little later into 2018 that I had started looking back into this case and I started talking to people. And
Wow.
something
Yeah.
that I heard from a couple of people off top when I started talking to them, the first words, like, this is a cult. This is a cult.
Yeah.
I was like, what?
Yeah.
And they were like, yeah, this is, a cult, blah, blah, blah. And I was like, no, you're crazy. I thought
Yeah.
this woman had lost her gourd when she started telling me about this. And I was like,
Yeah.
girl. And she's like, no, I'm for real. She's like, my son worked at the factory in Kokomo,
Oh, wow.
and she's like, he works with some of these people. And
Wow.
I'm telling you, like, this is bad.
Okay.
And so then the next person that I had heard from ended up working with somebody at the railroad company
Uh-huh.
that he worked with. And he said the guy felt that there was somebody involved that was closer than close. But he couldn't say who it was, but he said it was very, very bad and very, very dangerous.
Oh,
And it
wow.
was something that people do not talk about.
Yeah. I mean, I would be reticent. I would not want to be talking about that too loudly.
Mm-mm.
Yeah.
Not at all. You know what I mean? Because then
Hmm.
you're like, okay. And then you hear, you heard like the different rumors and stuff that were floating around in the early days.
Hmm.
And then, like, as it started to go along, like, you find out, like, this is so much worse
It's,
than what you could possibly imagine.
yeah.
Um,
Oh,
but yeah, I live not too far away from a spiritualist camp.
really?
Yeah. I'm like 8 minutes down the road from a spiritualist camp that was established in the 1800s.
Wow.
They have one of those shops that you used to work in where they sell like tarot cards and like
Oh
the
yeah.
um
Yeah.
stones and stuff. They also
Yeah.
have a labyrinth.
Oh
And
wow.
there's two labyrinths actually. There's a labyrinth at that location, and then there's a labyrinth in Logansport,
Wow, that's so cool.
right?
Yeah.
There's like these different places that you can go to like worship,
Oh,
like pray caves and
okay.
kinds of stuff. If you look on my
Yeah.
community page,
Yeah, definitely.
there's pictures of this place. It's gorgeous.
Oh
But
wow.
it's really just it's interesting, but definitely I started to understand, like, I was like, well, maybe it is a lot more prevalent with this type of belief
Hmm.
than I thought it was.
Yeah. 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 Especially for like veterans and um maybe if there's also a tendency to, well, in my area it's people that are out of prison, that
Mm,
are coming out of prison, that are, they had joined the Aryan Brotherhood just to survive, and they pick up a lot of the spiritualism when they're in there, and
right.
then come out. And I do think it has some benefits, and I don't think everybody that comes out is a racist or
It's
like,
true.
um, you know, they just try to get back to their regular lives. But if you're embedded too deeply in it, like you can't go back to a regular life a little bit.
Exactly.
Yeah.
Exactly. And it's crazy because there are so many of those groups here
Hmm.
uh, in Indiana alone, even in the prison systems. It's insane how much
Yeah.
there is. I
Yeah.
have a list. There's like about 40 something different gangs that were on this particular
Oh
list that had to do with that. And that didn't even include the affiliations for juveniles on
my
it.
God. And it's the juveniles that's the really scary stuff.
Oh,
Like,
yeah, for
yeah.
sure. For sure. I'll have to like get that thing and I can post it on my community page so you can see the different groups. But there was a group that like they were talking about that kind of is on this list that could connect is called the Peckerwood group.
Yeah. Okay.
Yeah, it's insane, but
That's crazy, man.
it's like hate groups or whatever. There's a
Yeah.
lot of craziness going on with
Right.
this.
Right.
Crazy, crazy.
But hey, I'm gonna get out of your hair, but thank you for having me on and let me talk, and
Yeah,
thank you for
thank you.
helping to make this clear, because like I'm just afraid more documents are gonna come out this week, and I'm just gonna be like, oh.
There is probably.
There's probably going to be a lot more to come out, especially as they finish up the depositions.
Okay.
Because if you noticed in that filing that came out where Rozzy was talking about the depositions, I believe he said he needed a couple more weeks on
Wow.
it.
Okay.
So it may be like
Right.
that
Well,
little
I'm
small,
gonna be looking for you. I'm gonna be like, where's Mama? I need to find her.
right?
Yeah.
Right? Well,
Yeah.
I'll go ahead and end this stream. If you just stay for just a few seconds, I just want
Oh,
to tell you something like privately.
okay. Okay. Cool.
All right. So thanks for watching, guys. We'll see you next time. Thanks. Have a great day.
Bye, guys.